And so if you'll bear with me, I'd like to go through what I think is the accurate state of the law. Slide 1. The bill that I introduced is lawful and returns control of administering on-street parking system and other functions to the citizens of Philadelphia, as we just heard. Right now, they don't have that kind of input, and that is unique to Philadelphia. The bill does not dissolve the Philadelphia Parking Authority, and to be clear, I'm introducing an amended bill just to take that language out, because it doesn't matter if it's in or out. It's a state-created entity, and we cannot dissolve the Parking Authority, but there may be some confusion, so I'm introducing an amended bill that removes that language, an amendment to the bill. Thank you, Mr. Chairman. The bill provides Philadelphians the opportunity to take back control of this critical municipal function. Second slide. The city does have the legal authority. The city has the legal authority to take back the functions of administering on-street parking system from the parking authority. The administration's reliance through this legal memorandum on the Pennsylvania court decision, City of Philadelphia versus Schweiker, decided in 2004, and other various statutes afterwards by the General Assembly is misplaced. Next slide. The Pennsylvania Constitution, Article 3, Section 32, prohibits the General Assembly from enacting local laws or special legislation regulating the affairs of counties and cities. By the way, this section was never argued by the city in any of its cases. The City of Philadelphia versus Schweiker the Supreme Court stated that the city abandoned its claims under Article 3, Section 32, and therefore they were not considered. Next slide. The Pennsylvania Constitution, in its current state, was established in 1874. The delegates to the convention in 1873 were motivated by reform. 10 years prior to that convention, corruption and favoritism in the General Assembly was rampant. Over 90% of the bills passed in that legislature were special and local. Reforms specifically addressed the General Assembly's interference in the affairs of municipalities. Distrust of the legislature is a hallmark of Pennsylvania's Constitution. Article 3 contains express procedural and substantive limitations on the General Assembly's powers. This contradicts the idea in the legal memorandum that the city is a creature of the General Assembly and therefore subject to what the General Assembly does. That's not true. Local control, the ability, are we on the next slide? I'm sorry. That should say Article 3, Section 32? Yes. Local control, the ability of counties and municipalities to make their own decisions is very important in Pennsylvania. To protect local control, the Pennsylvania Constitution, under Article 3, Section 32, prohibits the General Assembly from passing any local or special laws that regulate the affairs of counties, cities, and other political subdivisions. The General Assembly would violate the Pennsylvania Constitution if it legislated that the Philadelphia Parking Authority performed the city's functions and prevented Philadelphia from altering its relationship with the Parking Authority without the Parking Authority's consent, absent a bona fide state interest. Next slide. Act 22 of 2001. The Pennsylvania Constitution requires that the General Assembly enact general laws, not local or special laws, and that they serve the public interest. In 2001, the Pennsylvania Speaker of the House met with the Mayor of Philadelphia. The Mayor ignored him. The result was the introduction of Act 22 that passed, and Act 22 made the governor the person who appointed the board members of the Philadelphia Parking Authority, taking that power away from the mayor. Next slide. As a result, the leadership of the Philadelphia Parking Authority changed and no longer responded to the Mayor of Philadelphia. Act 22 also required the Philadelphia Parking Authority to transfer up to $45 million of its retained earnings to the Philadelphia School District on an annual basis. There was no city parking issue or problem that precipitated this change. Next slide. Consistent with the newly enacted amendments, the governor appointed 6 new members, 2 from the speaker, 2 from this Senate president pro tempore, 2 from the governor, to the existing 5 board member appointed by the mayor, basically giving the governor and the Republicans in Harrisburg a majority on the parking authority. The city files in common pleas court challenging the validity of the amendments. The city also sought injunctive relief to prevent the new members from being sworn in. Because the city failed to name the governor, the common pleas court lacked jurisdiction and transferred the case to the Commonwealth Court. The Commonwealth Court lacked jurisdiction and dismissed the case. Next slide. The city of Philadelphia then sought an emergency stay and exercise of King's Bench powers with the Pennsylvania Supreme Court. King's Bench is basically falling on the mercy of the court for justice. The Pennsylvania Supreme Court denied the city's request for relief regarding seating the newly constituted board, but stayed further implementation of the challenged amendments. Then it returned the matter to the Commonwealth Court and lifted its stay. So now the Commonwealth Court has jurisdiction. Next slide. The city files an amends its complaint, and files before the Commonwealth Court making the following allegations. It states that the General Assembly's amendments impermissibly and unconstitutionally infringe on the city's home rule charter and corresponding ordinances. It says the amendments violate the legislative pledge not to alter or limit any rights of PPA until all bonds have been fully bent and discharged. The city relied on this pledge in dealing with the PPA. It also stated that singling out the PPA basically is special legislation without substantial, valid, or rational basis. Next, it says that special or local amendments were passed without constitutionally required published notice. Then it claims that the amendments unconstitutionally delegate municipal functions to a special commission. And finally, that the amendments were passed in a bill which violated Pennsylvania's Constitution's single subject rule. Basically, the bill dealt with the city and the parking authority, and all these claims were dismissed for a number of reasons that were explained by the court. Next slide. In response to the city's amended complaint, the Commonwealth and the Philadelphia Parking Authority filed preliminary objections. A full panel of the Commonwealth Court granted their preliminary objections and dismissed the city's complaint. The city then files to the Pennsylvania Supreme Court. Next slide. The Pennsylvania Supreme Court affirms the order of the Commonwealth Court dismissing the city's case. The Pennsylvania Supreme Court found that the city did raise constitutional challenges, including Article 3, Section 32, against Act 22 in its amended complaint, but failed to state these issues in its list of questions presented on appeal, did not discuss them in the body of its brief, and did not include them in its prayer for relief. Therefore, the city abandoned these claims. Next slide. City of Philadelphia versus Schweiker is not on point, and it forms the basis of the Law Department's legal memo. The legal memorandum provided by the Law Department to City Council regarding the legal authority of Bill 160844 that we are hearing today relies heavily on City of Philadelphia versus Schweiker, where the Pennsylvania Supreme Court affirmed the Commonwealth's dismissal of the city's case. In Schweiker, the Pennsylvania Supreme Court found and specifically stated that the city had abandoned its claims under Article 3, Section 32. As a result, the Pennsylvania Supreme Court never considered the issue of constitutionally prohibited legislation by the General Assembly which interfered with Philadelphia's county and city functions. Next slide. Since the decision in City of Philadelphia versus Schweiker, the General Assembly has enacted various laws regarding on-street parking and other municipal functions, empowering the Philadelphia Parking Authority and possibly restricting the City of Philadelphia. The city has not challenged the constitutionality of these laws under Article 3, Section 32. The Philadelphia Parking Authority is not accountable to the City of Philadelphia. It has a direct relationship with the General Assembly. Through the General Assembly, the Philadelphia Parking Authority has obtained additional duties within our city that generates funds which are not known to city officials. These funds are collected by PPA and placed in non-city accounts and used outside the City of Philadelphia. That's to our detriment. Next slide. Act 9 of 2004. Act 9 extended the Philadelphia Parking Authority's administration of cities on-street parking for an additional 10 years after the 1994 agreement between the city and the parking authority expired. So the City of Philadelphia had an agreement with the parking authority, and legislatively, the General Assembly extended it till 2004 without the city's consent. Annual transfers from the Philadelphia Parking Authority to the city would be $25 million of net on-street parking revenue and the excess to Philadelphia School District. So Act 9 changed the formula. Instead of up to $45 million per year going to the school district, $25 million would go to the city if there was any money left over, and beyond that, anything above 25 would go to the school district. By the way, this provision expired on March 31st, 2014. The Law Department memorandum advises that the city cannot release its agreement with PPA without PPA's consent, the Philadelphia Parking Authority. The relevant language that they point to is in the statute. Quote, "The authority and the city," meaning the parking authority, "by mutual consent may modify the system of on-street parking regulation to the extent permitted by law." Next slide. In response to Act 9, the city filed a complaint, City of Philadelphia versus Rendell, in the Commonwealth Court, and that was decided in 2005, which challenged the new statutory amendment as, once again, interfering with the city's home rule charter, or home rule powers. The Commonwealth Court sustained the preliminary objections and dismissed the city's case. It stated that these issues had already been decided by the Supreme Court in City of Philadelphia versus Schweiker. Next slide. Footnote 23. However, footnote 23, Judge Levitt for the majority stated, Act 9 extended that contract. Act 9 did not divest the City Council of the ability to legislate on the subject of on-street parking that does not involve proprietary aspects of on-street parking. The dissent reads Act 9 to give the authority a legislative veto, relying on the language that, quote, "The authority and the city by mutual consent may modify the system of on-street parking regulation to the extent permitted by applicable law," end quote. The Parking Authority law makes it clear that on-street parking regulation involves acts of administration, supervision, and enforcement, not legislative acts. In any case, the authority has not attempted to veto an act of City Council. The mere possibility of that event does not give rise to a cause of action. Stated otherwise, the claim is not ripe for our review because it is not presented here. Next slide. July 2012 statute. This is the current statute that is now in question. It provides that from March 31st, 2014, when Act 9's provision extending the 1994 agreement between the city and the Parking Authority expires, that the Parking Authority shall enforce and administer all on-street parking regulation in Philadelphia, i.e. indefinitely. This statute did not extend an agreement. It simply legislated what will happen, and that is probably in violation of Article 330, Section 32. Unlike Act 9, the July 2012 statute does not extend the cooperation agreement. The General Assembly simply legislated the city function to the Philadelphia Parking Authority. July 2012 statute does not prohibit unilateral action by city regarding on-street parking and other functions. So nowhere in this statute does it say the city cannot take unilateral action, and such a prohibition would be unconstitutional absent a state interest. Next slide. In City of Philadelphia versus Schweiker, which started its path in 2001 and ended in 2004, the Philadelphia Parking Authority and the Commonwealth claimed that the state's interest in enacting Act 22, which took control of the Philadelphia Parking Authority from the city, was to provide adequate funds to the school district of Philadelphia. In 2001, the state also took control of Philadelphia's financially challenged school district. Since 2001, the Philadelphia Parking Authority has grown significantly and dramatically increased its revenues. However, its costs have also grown dramatically, and additional revenue generation authorized by the General Assembly is not provided to the city or the school district. In fact, the Philadelphia Parking Authority has never come close to giving the maximum of $45 million annually to this Philadelphia School District as provided in Act 22. That would be $675 million over 15 years. Next slide. Money promised to the school district has not been delivered. City Council held hearings regarding PPA's failure to provide funds to the Philadelphia School District. Public officials have expressed the opinion that the Philadelphia Parking Authority appears to provide as little funds as possible to the Philadelphia School District. The state has not funded the Philadelphia School District adequately. As a result, the city has raised property taxes 4 years in a row, increased the school's percentage of use and occupancy tax, and implemented a state-authorized cigarette tax, none of which provides the money that is needed. Today, the state-controlled Philadelphia School District is far worse off than it was in 2001, with even greater fiscal problems ahead and no expectation that the state will adequately fund it. Next slide. Article 3, Section 32 prohibits the General Assembly from enacting local or special laws. The July 2012 statute would be unconstitutional if it prohibits the City of Philadelphia from regulating its on-street parking and related functions. The articulated state interest in providing adequate funds to the Philadelphia School District has not happened, and there's no indication that it will. Bill 160844 lawfully returns cities' on-street parking functions and all related revenues to the City of Philadelphia as required by the Pennsylvania Constitution in Article 3, Section 32. What I would like to state is that during this entire time, since the takeover of the Parking Authority and all the other acts that were done by the General Legislature of Pennsylvania, General Assembly, the City Council of Philadelphia has never introduced a bill, and therefore there has never been the opportunity for the Parking Authority or the state to prohibit it, which would give us a cause of action, and I believe, and wind up with a ruling that such a prohibition would be in violation of the Pennsylvania Constitution, Article 3, Section 32. The courts have hinted to the City of Philadelphia that continually raising home rule charter issues, special commission issues, and all the other issues that were outlined in this legal memorandum is already decided by the Supreme Court, and that Article 3, Section 32 has not been raised. I would like to say that we should, in this committee, vote to favorably vote this bill out of committee, and that way we will be able to begin this process in motion. As was testified, we then have some choices to consider, which is nowhere near today. The first thing is we can renegotiate or actually negotiate an agreement between the city and the Philadelphia Parking Authority, because today there is no agreement. The legislature simply directed the city by state law to have the parking authority run its on-street parking function. I would say that's clearly a violation of the Constitution. If there is a hook that the Commonwealth, the General Assembly, or the Parking Authority can hang its hat on, it is that they have done so to adequately fund our schools. I think historically speaking, that has been proven not to be the case, in addition to which passing laws that create new powers within the City of Philadelphia to generate revenues that go to accounts outside of the City of Philadelphia or the school district is counter to the articulated state interest of funding schools. With that, I would certainly answer any questions that my colleagues may have. Thank you.
Thank you, Councilman.